In February of 2020, 42-year-old Sarah Boone was arrested and charged with the horrific murder of her live-in boyfriend, Jorge Torres. The two at that time had had a long history of mutual physical abuse, fueled primarily by the excessive consumption of alcoholic beverages. On the night in question, Sarah and Jorge seemingly played a sick game that resulted in Jorge being zipped inside of a suitcase. Sarah then completely closed the suitcase and had complete control over Jorge. Drunk, Sarah went on to record some of what was going to happen next on her cell phone. On the video, we can hear Sarah Boone, clearly drunk, taunting Jorge and telling him why he deserved to stay locked in the suitcase, all while you can hear Jorge in the background pleading for Sarah to set him free. Sarah went on to record two similar videos, and by comparing these two videos, we can tell she also flipped over the suitcase in between the two videos. During her interrogation, Sarah claimed that they were just playing a modified hide-and-seek game, and that although she intentionally left Jorge locked in the suitcase longer than he wanted to be there, she did not mean for him to stay in it overnight, nor did she mean for him to die in the suitcase. She claimed that she had left it partially open, and that Jorge can open it himself if he really needed to get out from the inside. She claims that she went upstairs to wait for him and fell asleep, or perhaps more accurately, passed out. The incident took place at night, between February 23rd and February 24th. On February 25th, 2020, after her full interrogation at the police station, she was arrested on charges of second-degree murder. Prosecutors filed an information, the formal charging document, about a month later, in March of 2020. When the case was first opened, Sarah filed an indigency application and was appointed the public defendant on February 26th of 2020. The next day, however, a private attorney, Mauricio Padilla of Miami, filed a notice of appearance. Followers of the cases involving the murder of FSU law professor Dan Markle may recognize this lawyer's name, as Mr. Padilla was one of the two Miami attorneys representing Sigfrido Garcia at the first trial involving that murder back in 2019. In early March, due to the appearance of Mr. Padilla, the public defender was allowed to withdraw from the case. Mr. Padilla thus became Sarah Boone's second lawyer, technically speaking. It is unclear how Mr. Padilla was retained to represent Sarah Boone, or how he was paid. The record does show, however, that Mr. Padilla succeeded in obtaining orders from the presiding judge, Judge Wayne Wooten, to pay for his travel expenses and accommodations in Orlando, while he traveled from Miami to Orlando to prepare the case for trial. Then, after obtaining several orders awarding costs to the defense, allowing Mr. Padilla to hire investigators and experts and paying them, on April 18th of 2022, Mr. Padilla moved to withdraw as counsel for Sarah Boone due to irreconcilable differences. 2 days later, on April 20th of 2022, Sarah Boone wrote her first letter to the court complaining about her attorney. In early May of 2022, the trial court, after granting Mr. Padilla's motion to withdraw, reappointed the public defender to represent Ms. Boone. However, in early June of 2022, the public defender's office moved to withdraw due to conflict of interest, since the office had represented Jorge Torres in a domestic violence case where Sarah Boone was the victim. Judge Wooten allowed the public defender to withdraw again, and in June of 2022, Judge Wooten appointed the third attorney to represent Ms. Boone, the Office of Regional Conflict Counsel. A few days later, the Office of Regional Conflict Counsel moved to withdraw due to a conflict of interest, since that office represented a witness in the case, Melissa Sexton, in various occasions. Judge Wooten allowed the office to withdraw and appointed Ms. Boone's fourth attorney, a private attorney off the conflict list, Mark Consolo. This fourth attorney, however, did not remain in the case for very long. About 2 weeks after appearing in the case, Mr. Consolo filed a motion to withdraw, citing an undisclosed conflict of interest. Mr. Consolo was allowed to withdraw, and in early July of 2022, Judge Wooten appointed Sarah Boone's fifth lawyer, another private lawyer off the conflicts list, Mr. Frank Bankowitz. During Mr. Bankowitz's tenure as her attorney, Sarah Boone started to write more letters to the court, complaining about her attorneys, including Mr. Bankowitz. Within 5 months of appearing in the case, Mr. Bankowitz filed a motion to withdraw, citing irreconcilable differences with his client. Judge Wooten initially denied Mr. Bankowitz's motion to withdraw, but several months later, in September of 2023, After receiving many more letters from Sarah Boone, Judge Wooten finally allowed Mr. Bankowitz to withdraw, and he appointed Sarah Boone's sixth lawyer, Mr. Winston Hobson. However, in January of 2024, after Mr. Hobson obtained several continuances, and after the judge received another complaining letter from Sarah Boone, Mr. Hobson moved to withdraw, citing irreconcilable differences and ethical considerations. By this time, the case had been transferred to another judge, the Honorable Michael Cranick. Judge Cranick granted Mr. Hobson's motion to withdraw and appointed another private attorney, Sarah Boone's seventh lawyer on the conflicts list, Patricia Ann Cashman, on February 9th of 2024. On June 7th of 2024, a status conference took place, with Sarah Boone present in the courtroom. During the hearing, Attorney Cashman indicated to the judge that her client, Sarah Boone, wanted to address the court with new concerns about her lawyer. The judge then inquired with Sarah Boone, and she handed a large package to the judge with a long letter inside detailing her complaints. Judge Cranick asked questions of Sarah Boone, trying to gather why she did not want to be represented by Miss Cashman. Sarah Boone indicated that Miss Cashman was rude to her. She also suggested that Miss Cashman did not give her straight answers regarding Sarah Boone's request that a motion for bond be filed. At the conclusion of the hearing, the judge indicated that he would review the letter and would share it with both sides' lawyers, and might set up a hearing, if needed, to address any legitimate concerns raised in Miss Boone's latest letter. A few days later, on June 11th of 2024, Miss Cashman filed a motion to withdraw, citing irreconcilable differences and ethical considerations. Judge Cranick has taken Miss Boone's letter under advisement and has not ruled on Miss Cashman's motion. So, what do you think? Will Miss Boone be appointed an eighth lawyer? Honorable Judge Cranick, why can't I use my constitutional rights? Am I the only one who cares about the ongoing violations? Have a bond, have all my medical records, have all my digital evidence and discovery, have all my paperwork, notes, letters, pictures, and everything of mine returned by former attorneys. Speak to my investigator. Have a complete download of my phone. Have any of my witness lists. Give any insight, understanding, clarification, or truths about my case, especially to my attorney. Be listened to by anyone, especially my attorney. Be respected for who I am truly, especially by my attorney, and not be disrespected by the mutated, malicious murderer all the world has falsely, incorrectly created and believes me to be. Be treated fairly, lawfully, and be protected by the justice system. Properly, rightfully, completely defend myself. See all and know the same as the world can and does, including my attorney, from all the phenomenal, non-permissive amount of my entire case being available on the global stage before my trial, and most important, before I had seen it myself. Why doesn't anyone know any already about my case? How about my side and everything about everything? Be correctly understood that I am not the problem for reasons I am on malappointed court attorney number 8. See my letter 7/21/2023. Say what I want and should, but all the world can and say it all wrong and warped. Why won't my attorney give me an honest answer? Show me everything she says she has and finished reviewing for my case, but withholds it from me after I ask repeatedly for and about. Give me an answer other than, I'm putting this to rest. That's not necessary, or I'm not having this conversation with you. Grant me access to anything I ask her for in and about my case. Like the detectives in my case, stop putting words in my mouth. Tell me what's going on in my case. It's been well over 100 days she has been my attorney, and I still do not know ongoing 5 years. Answer any of my questions. Ever ask me any questions. How can she supposedly know everything she needs to know from what she's been told, heard, read, or seen? Reassure that she's on my side, for me, and not against. Why have I already been judged in the court of public opinion? How did that happen? Why have I been sentenced by anticipation and condemned before my predicted trial? Why does my attorney and all the world think my case is already over? Your Honor, during our first introduction at my last withdrawal of court-appointed attorney number 7, Hobson, you stated to me your uninvolvement with any of my letters I write. I am still going to write my letters, as conduently as they are the world where all my potential jurors are located, and this is the only way anyone, including yourself, knows the very necessary insight to my continued disadvantages, hindrances, impediments I am still experiencing, on top of the new, spurring intentions to write. The race to the pulpit is unfair, and it is important to me that you are aware and understand what transpires when the news cameras are off and when all in between my status hearings. Two, as so many for the advantageous embezzler, racketeers, mindless lemmings, and altogether mean people can use their freedom of speech, not knowing me in any way other than what's being said by all the other mean people, and being said incredibly incorrectly. So can I. As the compelling, annoying detectives in my case, Kepsel had to falsify documents, and Lowen wore his gun for me to see. I am sure you are familiar with after watching all my plastered, highly misconstrued, over 30 million plus views just on one site interviews, in which they both repeatedly attempt to feed me their incorrect, incomplete, hypothesized opinions by stating to me everyone has their limits, at their seemingly endless point of perpetuality of nonsense and lawlessness still growing, and I am very much wanting to advance to the next level after ongoing 5 years now. A genuine concern limit has been reached. Why am I still not being included in my case? How much more of my care and self is being added hourly, especially after this letter gets loose, to the internet, increasing the mass infection and destruction of my hopes to have a fair trial? Anything fair. My side foremost, and wondering now if my attorney drank the punch like everyone else. All aforementioned reasons, and so many more, for this letter to be written, hoping to deter some of the unfair, one sided finger pointing of corruption and malpractice being directed at me only by those in the justice system, who are trying to deflect the shame and shock from me fearlessly challenging the status quo. And it must be so because it's in my face on the computer at the same time on my boob tube television. Brainwashed, ignorant followers of disbelief, conformity, and greed, trying unsuccessfully to make my life by character assassination seem worse than theirs. No, two, when anyone points their finger, one, it's impolite, and two, three, point back at you. How many tried to see it? Put the stone down, as there will be no casting of anything today, except maybe for the role of my part for all the pre-conclusioned documentaries and crystal ball real-life stories of true crime incorrectly formulated from everyone supposedly knowing me and judging who they think I am, when really happened and what is going to happen futuristically. Remember, 3 point back. Soothsaying is not a real job. To sum it up in the words of my attorney, after I told her to Google me, she stated, "There's a lot." To sum it up in the words of myself, the defendant, stated to my attorney after she stated that to me, "When can I see? How much longer do I have to wait? Or how many more attorneys must be withdrawn for me to be included in my case? And be included more than the world presently is. This is my case in every aspect. See all my aforementioned ongoing 5 year questions I am still waiting on for answers. Also, I want to make it known that I walked out on my attorney in our last meeting due to her unwarranted, uninformative, unprofessional, snotty attitude and her untruthful answers to my questions and beyond. The retarded, vicious circle we enter every time we meet is a waste of time. And I'm saying that being in jail with supposed endless amounts of time. How she treats me is extremely prejudiced, hostile, and unconcerned. She is very frustrating. Number one, to talk back or defeat in an endeavor. Number two, to induce feelings of insecurity, discouragement, or dissatisfaction. Number three, to bring in nothing. So much I presented my solution in order to coexist with and work together in a hopeful, progressive, positive, appropriate manner. I added pretend judge to our interactions so she could calm down and ease up on her condescension, offensive demeanor, and obvious prejudgment. She seems like everyone else not to remember I am innocent until adjudged otherwise. She treats me as if I am not. After my introduction and explanation for, with pretend judge, in the room or on the phone, I'm trying to help her understand how she is making herself extremely unwelcoming. When in front of a real judge and in the courtroom is how she should treat me, her client, at all times. I should not have to invent pretend judge in order to be, and am not at all wrong for wanting to be respected. No matter the outcome, I am innocent until adjudged otherwise. My attorney, everyone's, should be fair, unbiased, trustworthy, honest, supportive, informative, protective, automatically and effortlessly. I should feel secure, highly confident, proud in her representing my life. I do not, and have said to her many times regarding her monumental disbelief in me and my case, which I believe contributes greatly to her inimical attitude towards me. I am hoping by this letter she will pick up the sword of injustice and fight alongside, not against me, as so many unmotivated, overwhelmed, weak attorneys prior who bowed out ungracefully and crept away from the battlefield unsuccessful. My case equals bizarre, equals unknown, equals different, equals ignorant, equals misunderstood, equals unfair. This does not mean my case can't equal success, and in more way than one. While everyone continues to ring their bells of malevolence, I am ringing mine of hope, honor, plausibility, and boldness. Listen, I am not a murderer. The justice system should equal fair, faith, trust, respect. Innocent until and if adjudicated otherwise. 3 point back. Sarah Boone. Confused cat meme. Yes, thank you. June 4th, 2024. In addition to my previous letter intended for hand delivery on 6/7/2024 at my status hearing, today my attorney made a video visit to go over everything I have been asking her for and have also sent her personally in two letters, 520 and 525, all on the public video visitation box where on both sides of me, less than 5 inches away from my visit, other inmates were having their visits also. I have explained to my attorney numerous times previously in writing and verbally that despite the noise level, I do not in any way feel comfortable having in-depth private meetings regarding my entire criminal case on the visitation box, where there is no privacy whatsoever and held in an open bay dorm with more than 62 other interested all-ears inmates. I cannot fully participate, if at all, from the entire dorm, officers included, trying to participate also in my case. As always, my attorney did not listen or care after I repeatedly tried reminding her of my unsecure environment, barking at me that I could listen or not, still going, over speaking, and not at all allowing me to respond. After repeating to her over and over and over, while she's beginning to speak louder and over me, still to please schedule an in-person meeting where all can be discussed further privately. With no success of being heard, I disconnected the visit, as she was uncooperative. She is impossible. See previous letter or ask her for a copy of the two I sent her. I was trying to remedy or lessen before sending this to you, Your Honor, and not having to include. Now it's a race to the pulpit. My question, please, who acts like that and is still able to call themselves professional? The visitation box is primarily for family and friends to connect, and if a visit from an attorney, reminders, notices, and quick questions, not high-level, confidential case information. She, like other former attorneys who always blame their dysfunctions on me, said, "You don't like the answers I give you." What answers? See pages 1, 2, 3. I am not the problem, except that I want to and should be treated fairly, with respect, acting more professional than the paid. I've been doing this for over 40 years professional. After so long and in all the experience, common courtesy, customer service, and listening skills should have been acquired. All attorneys, do you remember why you even wanted to be one? Remind yourself. No one listens, and it works in everyone's favor but mine, that I am a murderer, stuck in jail so that they can pin on me their uninterested, unmotivated, hopeless, they're going to believe me over her haughty attitude. I am not wrong for not thinking less of myself because everyone else has and does, this present attorney foremost. The justice system expects me and other inmates, aka clients, to accept its subpar, nonchalant, hypocritical, next on the list attorneys they keep aimlessly throwing darts for and malappointing, praying they don't withdraw. I have not fired any attorneys appointed in my case. From me expecting the highest equal standards possible for wanting the absolute best outcome in my preposterous, mismanaged case. And representing myself is not an option, as both judges have now threatened me from being outspoken and intelligent in my observations of the ongoing abuse I am and have experienced. I have no new experiences from it always being the same, blame Boone. I refuse to be moved in wanting respect, no matter who everyone thinks I am. Clarity, inclusion, honesty, and professionalism. And another great reason not to have my case meetings on the public visitation box is my personal confidential inmate information, such as my visitation lists from 2020 to 2023, with names, etc., any interactions with inmates or officers, what I eat, when, and my personal jail calls also being thrown online. For what? To hate me more or to try to get others to because I don't eat breakfast or because I know some Latin, have short hair, my penmanship is nice, or because I am not getting fat and sleeping all day, but rather fully applying myself, fighting still, making everyone upset from not having to fabricate, mutate, splice, edit. The world apparently knows all. What's next? How many times I go to the bathroom and what function I perform? No one knows anything, nor seems to want to, from being comfortable in their own corruption and striving to be on top with ratings, web hits, and money. My case details, if anyone forgot, and if you think about it, all that keeps getting plastered and plagiarized, posted and poked fun of about me, it's all in my favor, proving myself right about all the mindless lemmings shut ins, the justice system advantageously abusing and profiting from everything in my cases, before my trial and before I've seen. Please be sure to read my attachment from FRCP Rule 3.220, subsection E, restricting disclosure. Am I the only one who thinks of these things? When can I win? In anything. It's coming. I am not the problem, and if anyone were to slip on my slides and have to experience, tolerate, or deal with any of what I have and am, would bravely be doing the same. Don't knock it till you try it. 3 point back. Race to the pulpit. Again, always, Sarah Boone.